Hi, everyone. Brian Vicente here. We are going to get going in just a minute or two. Thrilled to have y'all on the line. And we have a power-packed webinar here. I'm actually really excited to be talking about this content because I really think that with all the focus on the federal ban, that it sort of buried the lead on a equally important issue going on at the state level across the country. And I'll be diving into that, but really turning over to our expert attorneys that will really take us through from kind of end to end what this means for business owners, for consumers, and folks that are accessing hemp, intoxicating hemp products. So I really think it's crucial that we're having this conversation. It's about a minute past the hour, so we'll get going very, very, very shortly. We're thrilled to have hundreds of folks register for this, and we will be really banging through some high end content. So, of course, if you have follow up questions, we're always just a click away. You can call us, email us, but this is a big topic, and it's a crucial time to be really starting these discussions because the clock is ticking on what needs to happen at the state level to preserve hemp businesses. Um, so it's 2 minutes past the hour, and just to be respectful of people's time, we're all aware that the federal government has acted to essentially prohibit intoxicating hemp products in about 320 days. Right, that ban will go into effect for any product that's over zero point 0.4 milligrams of THC. With all the hyper focus on that incredibly important issue, I believe we've sort of missed the lead as a movement, and that's what this webinar is going to be getting into because. As we'll discuss today, there's an equally important issue at the state level, right? uh, Dozens of states, and we're going to walk through these at length today, have these trigger mechanisms that automatically mimic the Federal Controlled Substances Act, which essentially means that there's state hemp law, which we've been operating under. If you're operating in a hemp business in this country, you are operating in one state under one state's law, or maybe multiple state laws, will essentially go away. That state level protection, the state laws will now mimic the federal prohibition, and the opportunity to do business in that state will become much more tenuous. So we're going to walk through kind of what that looks like. But I do think it's just crucially important to focus in on where are you operating and what are you doing. And I think there's a lesson here from what we've seen with regulated cannabis and medical marijuana over the last 20 years. If you are dealing with a federally illegal product that you are operating under a strictly regulated state law, you're basically safe, right? We've found that the government has put out memos on this. They've given us guidance. If you sell cannabis at a legal store in Ohio and you're licensed, and Ohio has a state law saying you can do that, by and large, you've been pretty safe from federal prosecution. But if that state law goes away and you're not operating legally under the state law or the federal law, you're essentially viewed as a criminal drug dealer. Right. And so this is what we need to dig into today. This is the truth of what's going to happen in a couple dozen states unless action is taken at the state level this year, right? And basically in 2026. And we'll walk through what that looks like. Sometimes that's the state legislature acting to protect the state hemp laws. Sometimes it's the regulatory authority, and some states are okay. Some states are in the clear, right? So regardless, super important. If nothing changes at the federal level, we are going to be using state laws as our harbor to allow for these hemp businesses to continue operating. And a lot of those state laws are going to go away unless we take action. So big topic, super important, timely topic to kind of take us through today. I'm going to turn things over to my colleague Neil in a second, but we're going to be talking through what states we're looking at, what are these trigger laws. We're going to be looking at best practices in terms of how your business can plan around this and talking about opportunities to get involved to influence those state processes. So with that, I'm going to turn it over to my colleague Neil, who's going to talk about the triggering laws as we know them. Neil?
It's good to speak to everybody again. And as we covered somewhat in our last webinar, the federal government's new definition of hemp creates some pretty significant legal conflicts between the new definition and the state law, particularly in a lot of states where the hemp industry is thriving, where there's robust regulatory programs. and products are on many shelves outside of dispensary channels or outside of the D2C channel. So the critical question that we're going to be getting into is how do states respond? And again, just briefly, the answer hinges on each state's Controlled Substances Act. So, as everybody knows, the federal government has its own Controlled Substances Act, and then each state has implemented their own version of a Controlled Substances Act, some of which mirror the federal government's act, some of which are different. And when there's a change in the Federal Controlled Substances Act, states fall into one of three categories on their response. The first category is these automatic trigger states. There's about 27 states in this category where these states automatically adopt federal change unless there's a formal objection by the state regulatory agency responsible for enforcing the state CSA or an interested party. This creates a short window for the regulators and industry to intervene before the automatic adoption of this federal change to the definition of hemp, and a limit of 0.4 milligrams of THC per container for consumable hemp products. The second bucket, where there are about 13 states, are rulemaking states. So these states include California, New York, Colorado, and here these states require legislative or administrative action before implementing any kind of federal change to the Controlled Substances Act. These states certainly have more time to figure out how to respond to this federal change once it goes into effect in November of 2026. And they provide a really good opportunity for strategic engagement with the industry. And finally, the third bucket are discretionary states, and these states, these states include Florida, Georgia, Virginia, and what happens in these states are that the state has the authority to follow the federal schedule, but only if they choose to do so through a proper rulemaking process. So they don't have to, but they can. So again, like the rulemaking states, there's a very good opportunity to engage with state lawmakers on how the state responds to these significant federal changes. So yeah, this is framing up for the further, the greater conversation today. And the takeaway from this brief overview really should be that understanding which bucket your state falls into is the first step in understanding how these new changes affect your business at the state level, and then from there, trying to implement targeted legal or policy strategies to protect access and regulatory certainty in your markets across the country. So as we get into the various state responses thus far, I'm gonna hand it over to Cassia to dive into some states that have been mulling this over.
Thanks, Neil. This is very preliminary information, and I also want to explain that we're going to kind of go through some of what's a number of states have been talking about recently. This is obviously very early chatter. There's a lot of action that can and will influence the direction that various states take in the coming year, including the potential for federal reform, which I know everybody is very focused on. And state and federal politics are very, linked in this area. So even though we're talking about sort of preliminary tips from some of these states today about what direction they may go, it's not, necessarily going to be the final picture. And this is a rapidly evolving landscape. So just to give that caveat. Second caveat is we're going to be talking about initial state sort of responses or comments regarding the federal hemp ban in response to the federal hemp ban as to how it may impact their own state laws. This is somewhat separate from the triggering discussion, although it's also informed by it. So you'll see these are just some initial states that have made comments, or in the case of Ohio, actually just passed a bill, which is not SB 56, which has not yet been signed by the governor. So not in law yet, but that closely follows the federal law. So of these three states, Ohio is an automatic trigger state, but I don't think that the passage of SB 56, which had long been in the works, and as you know, those of you who follow the industry know, Ohio's always been a tricky state for both cannabis and now hemp legislation and policy, despite being an adult use marijuana state. It's not necessarily the trigger laws that are impacting, you know, how these initial responses are going. Alabama is a trigger state with an objection right. They have adopted a comprehensive hemp policy earlier this year, and the lawmaker who was responsible for that made some very preliminary comments suggesting that, you know, only topicals would be allowed going forward. This is not legislation in Alabama, so again, this is very preliminary. Pennsylvania, there's been some rumors about that state and whether it may follow the federal hemp ban and adopt something. Again, Pennsylvania, not a trigger state, not an automatic trigger state, but it's Pennsylvania, also a state that has had quite a robust history of both hemp and adult use cannabis legislation, none of which has successfully passed. So I'm not going to say much more about that until we see something new introduced in Pennsylvania. But Ohio is the state that's kind of unfortunately leading the charge. If you look at SB 56, it closely mirrors the federal language with the 0.4 total THC per container limit for most products except beverage, which has a narrow exemption at 5 milligrams with one serving per container. So there is a beverage carve out, but there is a provision that will roll off when a federal law does change. So Ohio getting kind of a win for hemp beverage and put into SB 56, but still hedging and indicating that they will follow federal law on this topic. And with that, I will pass the baton.
All right, I'll jump back in to discuss some states that have, like Cassie mentioned, made announcements publicly about what their intention is. And the next states that I'm going to cover are states that have publicly said, whether through announcements on the respective agency websites or through rulemaking hearings, are states that are awaiting on federal action. They're states that have hemp programs that are going through some changes, and they've again said publicly that, okay, we know there's a change. We're going to wait on some more guidance from the federal government, specifically the FDA, to figure out kind of how to respond. So these states include Tennessee, New Mexico, and Hawaii. And out of those states, Tennessee, for example, is an automatic trigger state. So with a chance to object to the automatic trigger of hemp products with more than 0.4 milligrams of THC being moved back into the Schedule 1 on the State Controlled Substances Act. So the Tennessee Department of Agriculture has been pretty transparent with their thought process. They've updated their website down a couple of times since this federal change, and they're aware of the hemp-related provisions included in the federal funding legislation, and they've stated that its hemp program will remain unchanged under existing state law currently, but they're waiting. But their main priority right now is just waiting to see what the FDA says. They're waiting for federal agencies to develop guidance to implement the new provisions that the federal legislature made to the definition of hemp. And the regulation of hemp production and hemp-derived cannabinoid products in Tennessee will again currently remain unchanged at this time. The TDA has made very clear that they're going to notify stakeholders of any regulatory changes that may impact them as this landscape evolves. But as we get closer and closer to the November 2026 deadline, and barring any new change to this federal change, I'm pretty sure we'll start to see more activity from not just the Tennessee Department of Agriculture, but other relevant agencies that are more focused on implementing the State Controlled Substances Act. The next state in this kind of this bucket of we're going to wait and see what the federal government does and how federal agencies react is New Mexico. And New Mexico's Environment Department is tasked with regulating hemp products, and they're right smack in the middle of rulemaking. And during their most recent rulemaking hearing, I think it was December 2nd or sometime in early December, the department said that they're also going to take a kind of wait and see approach. They recognize that the new federal change prohibits synthetic cannabinoids, which already aligns with New Mexico's existing efforts, and the federal government's again redefinition of hemp to exclude synthetics already supports what New Mexico is doing. And regarding the new THC potency limit, the agency noted during this presentation that the federal proposal of 0.4 milligrams, obviously it's significantly stricter than a new 2 milligram per serving limit that the department is has currently proposed for state rules. And the agency confirmed that this strict 0.4 milligram limit is on their radar. I think notably, New Mexico is one of the states that has discretion to schedule substances in accordance with federal law or schedule them separately. So I think, unlike Tennessee, the regulatory agency here will have a little bit more discretion and say over what happens to the state program, the program within the state. And finally, the last state we'll highlight in this wait and see bucket is Hawaii. Hawaii, like Tennessee, is in the bucket of an automatic trigger unless there's an objection. Like New Mexico, Hawaii is also in the middle of rulemaking processes. And during a recent rulemaking webinar, the agency in charge of hemp regulation noted that federal statute prohibits synthetic cannabinoids and acknowledges the 0.4 milligram total THC per container limit. They acknowledge that that's extremely low. But despite the federal changes, the agency does not yet have a lot of guidance from federal agencies. They're taking this wait and see approach. They mentioned that the FDA has a 90-day timeline, which is already underway to publish a required list of naturally produced cannabinoids and clarify the meaning of container. And the agency is expecting the FDA to do just that before they offer additional guidance or updates. And because of this wait and see approach, Hawaii is moving forward with their new hemp program. So in summary, all three of these state agencies are aware of the permanent statutory shift that tightens the restrictions around hemp products, but they are all currently maintaining the status quo while they await more federal guidance for mandating any more permanent change at the state level, and before determining whether figuring out how to abide by their mandatory controlled substance trigger laws. I will now turn it over to Sean to discuss the next group of states.
Thank you. Yeah, the last group of states are states considering moving ahead with their state regulated hemp programs, regardless of whether hemp remains unscheduled under federal law or if the current federal law takes effect in a year, that hemp becomes Schedule 1 marijuana on the same playing field as marijuana. And Texas is a really interesting state because, as many folks know, it's obviously a huge consumer market, a huge patient market. And as of last week, the medical cannabis program expanded significantly with the issuance of 9 new licenses. There will be a total of 15 medical cannabis licensees after they issue the next round in April. And then there is an expanded medical cannabis program at the same time. The very robust hemp industry and its consumers are looking at the Texas market and legal landscape and uncertain about the future. And Texas is an interesting state with respect to the trigger laws. They're not automatic, but essentially automatic by the DEA final order. So the DEA will ultimately have to issue a final order in the Federal Register to officially reschedule hemp consistent with the new federal law. Once that happens, they have to automatically conform to the federal law unless they make a legislative change. And as many folks know, Texas only meets every other year, so the next legislative session is not until 2027. So Texas will have to take some action to ensure hemp remains state legal if that's what it desires to do. Texas's public position's a bit divided and conflicted, and I think certainly still being informed by federal developments. Lieutenant Governor Dan Patrick has, championed the federal ban as, a victory and been, a leader at the state level in unsuccessfully attempting to ban hemp products over the past year. At the same time, the state has, moved forward with its regulated hemp program. The governor's office has stated that it's proceeding with rulemaking along the lines of Governor Abbott's executive order establishing fundamental safety age verification regulations for hemp products. The TABC, the Texas Alcoholic Beverage Commission, is proceeding with their formal adoption of regulations mandated by Governor Abbott's order for age gating and similar regulations for the liquor licensees. And Governor Abbott's directed the Department of Public Safety to increase enforcement against actions against businesses not in compliance with the existing state hemp laws, specifically targeting sales to minors and unlawful activities. And we've had some, unusual cannabis supporters like Senator Ted Cruz speak out on X with his position that states should have the authority to regulate their own hemp and marijuana products. He also was one of the senators to vote against the motion to table Rand Paul's amendment that would have removed the restriction language. So, Texas has some interesting signals from the governor's office and from key Senate leadership in the agencies as far as proceeding with their state hemp program. And I think the state will have some interesting considerations and intersections with the growing cannabis program. So certainly an important state to watch. And then, others that we're looking at that are considering moving forward are certainly, traditional progressive marijuana states like here in Colorado. Minnesota has made statements, noting that it's, committed to its hemp program and its robust regulatory framework for its low potency hemp product industry, and have been advocating at the federal level for protections to the hemp program. We're even seeing signals from states like South Carolina where leading legislatures said there's, they imminently need to pass regulations to regulate hemp products at the state level for public safety and, not wait for the federal government. So I think that, this will be a really pivotal year to see how states regulate cannabis, whether it's marijuana and hemp, and how those intersect together, especially in some of these, southern states that don't have adult use cannabis, like Texas and South Carolina, where, agencies and leadership are now getting educated and informed, not just on the law, but on consumer safety, the stability of their industry and jobs and the tax revenue on both sides. So, will be a really important and I think pivotal year for cannabis reform in that capacity, because many of these states were not even engaged in this conversation and informed on these issues before. So I think that's a natural segue to turn it back to Brian to talk more about how the state hemp considerations will intersect with marijuana reform. And I think that will mean a big year in state reform in 2026.
Yeah, thank you, Sean. And we will be jumping into some kind of business considerations, compliance considerations in just a minute or two. But I think, thus far we've been showing you a lot of maps. This is the final map we'll show. We are going to send around this full recording and we can share these slides with all of y'all. I guess what I would say at this mid juncture is I feel every hour, every minute you're spending trying to change the federal law and dollar you're spending trying to change the federal law to close the ban, you should be spending an equal amount of time figuring out what's going on in the states you operate. Are they a trigger state, and what needs to happen to change the state law in 2026 to protect your business? So hopefully that's coming across. And I know we've shown a lot of slides and presented a lot of information, but the state piece is really just so crucial to having any operating businesses should nothing change in the federal law. At the federal level in the next year. So as if that weren't enough, we have a number of other kind of changes going on in 2026 or potential changes. To sort of preface this, if you are a hemp business and you're in a state that does not take the action to protect your state business in the next year, you might want to then look at getting a cannabis business in one of those states, right? If it's a state that allows for adult use or medical businesses. So we've been helping folks kind of strategize that sort of piece, but that plays into this slide. Red is, I would say, bad here. These are states that are looking at prohibiting either their adult use programs on the ballot next November in Maine and Massachusetts, or Idaho is looking to sort of restrict the ballot process entirely, so only the legislature can decide what to do on cannabis. So again, if you're active in any of those three states, you should be thinking about, can I get involved in those campaigns to try to fight those measures to allow for these businesses to continue to thrive. Our blue states are just states that may very well legalize adult use cannabis in 2026. Some of these laws are the language is baked, right? So Florida, that language has been written. It's worth analyzing to see how that will affect your hemp or cannabis business should it pass. But other states, this is not decided yet, right? We have Virginia on here, which of course has legalized adult use cannabis, but has not legalized the regulatory structure around adult use cannabis, but they are charging towards doing that. And there will be a legislative session. I think a bill was introduced this week, to allow for, adult use regulated sales from storefronts, right? And if you're a operating hemp business in that state, or a prospective adult use operator or what have you, you want to be able to get involved, make sure that your business is protected in the languages as that gets developed. Same thing in Pennsylvania, same thing in Hawaii. I believe they have a strong chance of legalizing cannabis in 2026 via the legislatures. I can't guarantee that, but they've been fighting it for a long time. And I think both Pennsylvania and Hawaii are likely to do so. If you want to operate there, it's worth trying to get involved in that process, talk to the campaigns, the lobbyists, to see, how your business could potentially get in that state. And I would sort of throw New Hampshire in there as well. It's a little more of a long shot, but certainly worth keeping an eye on too. So with that, let's jump into some business and sort of compliance concerns at the state level, given this sort of federal issue and pending sort of state issues as well. So Cassia and Charlie, I think you're going to jump in here.
Yeah, sorry. So I talk about some immediate, sorry about the lighting here. Talk about some immediate issues here that we're dealing with. One is question, obviously. So, and a lot of this sort of trends to sort of like, now hemp businesses are dealing with issues that were previously only issues for cannabis businesses. So the big one here is payment processing. So, the law has not changed, but we've heard people saying, hey, our payment processor is pulling out of the industry. Obviously, it hasn't been everyone yet, but because the law hasn't changed, but we have heard it's occurring. Same thing for banking. So here, one is, keep your ear to the ground thinking about terms of backup options, which is sort of the advice we give to cannabis companies. Because, a lot of these, um, a lot of, you may have a bank now, but the bank may pull out of the industry, right? So you should always have sort of a backup option in mind. When it comes to payment processing, I mean, once the law goes into effect, you're now going to be the world of cannabis, which is essentially a world without payment processing. And I put a little asterisk there because, there are people that offer payment processing services to cannabis operators, but you need to be aware that the branded credit cards will not work with cannabis companies. And essentially what's going on is masking, which is just a fancy word for fraud. And you also need to be quite careful here in terms of the contracts these providers will ask you to sign. I've worked on a number of these issues. They can be quite nasty in terms of having early break fees, and these guys will go after you. So don't sign up to a long-term payment processing agreement without having a lawyer look at it. If it, that's good advice in general, but it's especially important if you're dealing with someone who's saying, "Hey, I can get you payment processing even when the law changes." You got to be really careful with that. There are a few other things I think we'll see, just sort of looking down the road, right? Trying to look around the corner about as we get closer to the effective date. One is, bankruptcy. So bankruptcy will not be really an option. I would say it's already probably not an option in the Chapter 11 sense, because, in Chapter 11, a trustee empowered by the federal government sort of steps in to run the business while the business is restructured. They they have a clear statement on this, right? From in the cannabis world, the trustees will not allow themselves to be appointed as trustees for a cannabis business because they don't want to have to run a federally legal business. So that's why, with very, very narrow exceptions that are not really applicable, you can't really do a Chapter 11 restructuring in cannabis, which is why everyone does either receiverships or an Article 9 sale, which is kind of the latest trend here. And that's like it's a whole webinar there, so I won't get into that. But the last thing I'll say on this is there's really not much there to do, right? Other than to say, just be aware that you're kind of limited to the state options, because it'd be unusual to be able to do a bankruptcy, sort of they can take quite some time and your creditors likely would resist it. But on this, also think about trademarks. Um, as you transition to being potentially transition to being a cannabis company, um, note that you cannot trademark federally legal actions, right? You can patent something that's federally legal, right? You get a patent for an atomic bomb, right? Even though you could never possess an atomic bomb yourself, but you could get a patent for it. But you cannot trademark something that's illegal. So, in the cannabis world, you have to sort of trademark around the Controlled Substances Act. So it's definitely something to think about. What's your IP protective strategy, right? Maybe because we may be dealing with a situation where, maybe hemp beverages come back, but they come back after they go away, right? So this is kind of what I call like the, hibernation strategy, right? You could be in a situation where you go into the cannabis world for a while and then you reemerge, because we don't know what the timing is like with, with these regulatory changes, though obviously, we got to push ahead and try and fix the law as soon as we can, but it may not occur before it goes into effect. So don't get caught without trademark protection. And the last two things I'll talk about here are sort of, again, in the spirit of let's think about how we transition to a cannabis company. One is structuring, which I talked a little bit about last time, which is, you may have a business where you can't directly hold a cannabis license either because you're publicly traded, some of your investors aren't comfortable with it, various other reasons. You shouldn't consider this a a reason that you cannot enter the cannabis industry. I mean, if you look at these Canadian companies that have entered the U.S. cannabis market, the people that are traded on NASDAQ can't own a license in the U.S., but they've been able to set up off-balance sheet arrangements. So it doesn't matter what your situation is. I would strongly encourage you to at least explore kind of like an off-balance sheet SPV type arrangement. Have you talk about that. It's very unique and personalized, but essentially it's some sort of option to buy into it, and you have, maybe the executives of the company directly own the business, right? And then you can keep your business going as you transition to a cannabis business. And the last thing I'll say is, you know, obviously, when you're in the cannabis world, each state is its own sort of unique universe. So to have a national product, you essentially need to have production partners in multiple states. And that's the way it works in cannabis. And you have these IP licensing deals. So you need to find partners in these different states, enter into agreements with them, and then deal with sort of the IP licensing issues that are common in cannabis, which again, that's a whole presentation there. But things like the big one is collections. You don't want to be caught sort of not being paid and then being sort of a creditor to one of these companies, but also things like Salesforce and distribution, right? Because the production partner is not necessarily going to be pushing this product into stores for you. You're probably going to have to take ownership of the sales process, and someone's got to be out there pushing this onto shelves and pushing this to consumers, because, if consumers can't get this in their liquor stores anymore, maybe they're going to go to the dispensary to pick it up. Turn over to Cassia.
Yeah, I'm just going to hit real briefly on compliance. I don't think this should come as a huge surprise to anybody. But there's been an uptick in enforcement and compliance against and involving hemp products, even well before the appropriations language passed with the delayed sort of ban language. It's been in response to the well-publicized availability of some of these products that appeal to children primarily, and the sort of widespread nature of the products. It's primarily been enforcement at the retail level. In certain states have been, as opposed to DDC, and certain states have been a lot more vigilant than others. Since the appropriations language passed earlier in November, it's been about a month, we have seen in certain states signals that enforcement and sort of compliance scrutiny of the products will increase and be on the uptick in the year to come, as we work towards different policy outcomes that will prevent that happening. As a business, another item to focus on is fundamental compliance. We used to say for years in the marijuana side of the cannabis plant industry that it was essentially a compliance industry, that if you did well enough at the end of the day, you could sell some marijuana. And for years, hemp has been attractive for many reasons, including much less compliance scrutiny, but those days are essentially over. Most of the conversation is moving towards unifying the plants from a regulatory perspective, at the federal level, certainly, and definitely at states. I think there's some exciting potential there, but it will continue to be, and perhaps for the first time, be for hemp products, a highly regulated product again. So focusing on compliance is important. And making sure that you understand the labels, where it's sold, etc. It's more pressing still at retail than for D2C. But we've also seen an uptick in product liability cases in the past year or so around ingredients, labels, testing, access to kids, attracted to kids, all sorts of different issues on a state-by-state basis. And it's very easy for people to Google and find, those images on your website as well. So, just because you're limited to D2C sales doesn't, wholly prevent you from, landing in these issues. So something to consider as you look at your 2026 program, in addition to, policy and legislative efforts. And with that, I'm going to turn it back over to Sean and Neil to talk a little bit about more of some of those policy considerations. Thanks so much.
So what next? What's the industry doing? How is the industry responding to this massive federal change? Is there a chance that it changes once again to a more permissive environment? I don't know. I'd love to pull up my crystal ball and pontificate on what will or won't happen. But that's no one can predict that just yet. But what we can do is give a brief overview of some of the vehicles the industry are relying on to effectuate additional change, to change things back to a more permissive environment that's more defined and more predictable. The first kind of key date is January 31st, which is when another CR is expected. Industry is trying to get a 1-year extension of the implementation date for these federal hemp changes. However, we're hearing that from federal lobbyists that the federal legislature is not very keen on this solution because that just kicks the can down the road a little bit longer. The legislature wants to see some real robust oversight and regulation of the industry, and just prolonging what could be the inevitable is not something they want to support. Some of the other vehicles that we're seeing, and really the next key date begins in March of 2026, is when the Farm Bill debate, the 2026 Farm Bill debate, likely kicks off again. There'll certainly be attempts to address the definition of hemp and include some more robust regulatory oversight language in any new version of the Farm Bill. Whether it's a standalone bill or part of another CR is anyone's guess. But I think, again, going back to what I said about kicking the can down the road, some of the more interesting solutions appear to be robust regulatory hemp bills that we're starting to see trickle in. For example, Senator Wyden just an hour ago introduced a new regulatory bill with Senator Merkley. It's similar to the bill he introduced last year with some key changes. One of those changes includes an active milligram cap, where the bill last year did not have any cap or did not even mention a cap. His new bill would have a 5 milligram per serving of THC per serving cap and a max of 50 milligrams per package or container. Those limits would change according to the product type. Like I said, the bill came out just about an hour ago, so we're diving into it, and we'll certainly update folks with what else is in there. Another potential solution is a regulatory bill from Congressman Griffith out of Virginia. Last year, Congressman Griffith introduced a discussion draft of a pretty in-depth regulatory model for hemp cannabinoid products. He is expected to introduce an updated version of that bill in response to this federal change to hemp. So whether folks can align with the Griffith bill, the Wyden bill, it will remain to be seen. But I think any kind of key element to these bills or any solution is a states' rights element that allows the state to regulate it as they see fit with some sort of federal baseline. And on that note, Senator Paul is rumored to be working on a states' rights specific bill that could be introduced over the next several weeks, if not early next year. So those are just a couple of things that we're tracking, and a couple of the solutions industry folks are starting to talk about and get behind. Next, we can move into what federal oversight looks like under this current regime, under this current legislation, what the FDA should be doing, what the DEA is likely to do, And there was, I would direct everybody to a very recent Congressional Research Services report on this issue, on the impact of this federal change to the definition of hemp. I agree with the CRS conclusion that should things not change in 1 year, then I think both the FDA and DEA will be hard pressed to have any sort of meaningful enforcement, simply because the lack of resources and their enforcement priorities are likely going to be something a little bit more pressing than than hemp products with more than 0.4 milligrams of THC in it. There's a lot of uncertainty, and with uncertainty breeds unpredictability, and with again a lack of resources. I think we're unlikely to see any meaningful enforcement of whatever change there really is going to be over the next year. Finally, I'm going to toss it back to Sean to discuss under the current legislation what the FDA should be doing, what their timeline is, and what's likely to come down the pike.
Thank you. Yeah, it's really interesting. I mean, I think since we've had over a decade of state cannabis programs in the form of marijuana and hemp, we've seen a general policy of not using enforcement resources and priorities, and where at least state businesses are compliant with state law. So a departure from that will be a significant change, and that's why watching how the agencies respond to this change in federal law, and whether they do change either enforcement priorities or resource the agencies differently to enforce federal law, will materially inform business and considerations and how state legislatures are going to move forward. And the first key deadline is on the FDA. They are mandated within 90 days of enactment of the new definition, which was November 12th. So about February 10th, 2026. They have to publish several lists clarifying some key provisions around the definition of hemp. The first is a list of all known cannabinoids naturally produced by the cannabis plant. So that will establish the boundary of sort of what's considered natural and therefore potentially lawful. So the list of all THC class cannabinoids naturally occurring in the plant, and that will also inform the scope of the total THC standard. So what exactly we are calculating when we get to calculating our total THC standard that we're now mandated to comply with under federal law. And then importantly, additional clarification on what qualifies as a container, which is going to be critical for both interpreting and enforcing the 0.4 total THC per container limit. We understand FDA is, actively engaged in, discussing and considering these issues, and, fulfilling their mandate. However, as most folks in hemp and cannabis know, since we've been waiting since 2018 for the FDA to regulate cannabinoids as they were mandated to under the Farm Bill, and they've subsequently, stated over and over that they don't believe their framework is sufficient for cannabinoid regulation. They want Congress to give them a new framework. It's possible they miss the statutory deadline. They often miss statutory deadlines, sometimes by years. This happened with cosmetic CGMP rules and other matters. So absent additional funding and significant engagement, it's possible they miss the deadline. But like I said, it's early. There's a lot of engagement with FDA. But I think watching what happens with federal enforcement priorities and federal resources with respect to hemp and cannabis is going to, materially inform what the landscape is going to look like. Other new milestones are going to be the continuing resolution at the end of January. Also, looking at the Farm Bill as an important vehicle for the definition of hemp in 2026. And, that's expected mid to late 2026. That could get impacted by, midterms and other material events. So, folks are really looking at any potential legislative vehicle as an opportunity to fix the definition of hemp or to regulate cannabis in general. The continuing resolution, the expiration of the continuing resolution is to be determined. Likely March or April is when that would expire, and we'll have more information on that as things progress. And then, of course, the effective date of the ban, which will be November 12th, 2026. So that's where coming back, critical to look at each of your state laws, whether the trigger is automatic, whether something needs to happen in the legislative session, and whether there needs to be engagement with controlling or regulating authorities on these matters to take action before the effective date of the ban. And some states like Texas may not be in session then. So with that, I will kick it back to Brian for some final notes.
Yeah, thank you, Sean. And we're gonna go ahead and close it out. But Sean spoke about how we've learned that if you're following state law, you don't stand a very high chance of federal prosecution, even if you're selling a federally legal product. And I hope that's a takeaway for folks today: is that hemp businesses currently operate under state laws. A lot of those state laws are changing significantly, if not going away in 2026. So we've kind of given you a bit of the roadmap to explore what's going on in the states where you operate. What can you do to get involved? We'd love to chat with folks more about that moving forward in order to sort of safeguard your businesses, safeguard access in those states. So we will be sending this webinar around, and I want to thank the panelists for this wonderful discussion, and we are here for any of your needs in this space. Thank you so much.
Thank you.